A former police officer looking to become a lawyer has faced opposition in the High Court. Ethan James Brown was acquitted of sexual offending when he was aged 19 and 20, but left the police force soon after. He's now completed a law degree and hopes to be admitted to the bar, but the Law Society isn't letting him. The case was heard today in the High Court in Auckland. Our reporter Tom Furley was there, and I asked Tom, what's it all about?
In order to become a barrister or a solicitor, you have to be admitted to the bar, and part of that process you have to prove your good character. And so normally the way people go about that is they get a certificate of character from the Law Society, but in Ethan Brown's case he was declined that. They didn't give it to him. So the only other way he has of fulfilling that is to apply to the High Court, which he's done today. So it's heard in the High Court today, but once again the Law Society is opposing that.
Now Tom, can you explain the Law Society's opposition to us? Because Ethan Brown was acquitted, right?
Yeah, so he was acquitted, so no charges were successful. Basically their opposition is more related not to the nature of the allegations or the fact that there were criminal proceedings, but more to his honesty and his attitude towards them afterwards. So basically he took the stand this morning and he was cross-examined by the Law Society's lawyer, Paul Collins. And the first thing that he brought up was why initially when he came to them he didn't provide many details about any disciplinary action that was taken by his former employers, the police. Basically, Mr. Brown had said that there was no disciplinary action because there was an employment investigation, not a disciplinary action. It never went to a disciplinary hearing. It was just an employment investigation, and he had resigned afterwards. So there was no actual action taken against him. The other thing that Mr. Collins and the Law Society really focused on was one particular claimant. Now, it's important to note that this claimant wasn't heard as part of any criminal proceeding, so these are all allegations, but he said that basically Mr. Brown hadn't been honest with his knowledge of the situation. He had maintained that to everyone, his employer, throughout the investigation as well, right up to an affidavit as well, maintained that this girl had told him that she was 16. However, in texts that were read out to the court today, it was clear that she had told him pretty early on in their correspondence that she was actually 13. So he actually changed his tack a little bit in an affidavit in February and said, well, actually I must have known she was underage at the time, but he hadn't told the Law Society of that change in position. And basically Mr. Collins said that because there was no evidence that he was told by her that she was 16, basically he had been dishonest about it this entire time and tried to cover it up. Mr. Brown did accept that he hadn't told the Law Society about it and that his memory had failed him, but he said he wasn't trying to mislead them. He said that he obviously tried to block out his past behaviour, which he said was disgusting, and tried to move on, but not to mislead them. So Mr. Brown has said that he wasn't a predator, and at 27, he's now 27, he was now a very different person to his 19-year-old self. So his lawyer, Peter Davies, said there was no suggestion that his earlier behaviour had been repeated, and he said he was now a fit and proper person to become a barrister or a solicitor, and he said a lot of water had gone under the bridge since then. His client had made a new life for himself. He'd done his law degree, he graduated in 2016, and that he wasn't trying to be dishonest at all. He said that in fact previous cases when getting admitted to the bar, despite people having actual convictions previously, they'd been okay, and that actually the court should be relying on his future attitude, the future he had ahead of him, not his past mistakes. So the judge, Justice Wiley, has reserved his decision, so it's in his hands now.
Tom Furley from outside the High Court in Auckland earlier this afternoon.